Call the final case on this week's docket, in re Curtis Holmes, 118-3110.
Good morning. Penny Moylan appearing on behalf of the Disciplinary Administrator's Office. Justice Lukert, I would request 5 minutes rebuttal.
All right, 5 minutes is granted.
And as the court is well aware, this is original action and attorney discipline. This matter arises out of the respondent's suspension from the practice of law for failure to timely remit his registration fee and then a subsequent failure to timely remit a late fee. The allegations in the complaint involve his unauthorized practice of law during the time of suspension, his failure to notify court, clients, and opposing counsel, to also include notifying them orally and in writing of the suspension, and then also dishonest or deceptive practices or statements made during the disciplinary investigation regarding the same. The panel found violations of 1.4, which is communication, for failing to advise his clients that he had been suspended, 1.16 for failure to terminate the representation when it would violate the rules of professional conduct, 5.5 the unauthorized practice of law, 8.1 disciplinary matters. I need to pause. Is my timer working?
You got a minute.
Okay. All right. Okay. 8.1, disciplinary matters, 8.4C, dishonest conduct, and 8.4D, conduct prejudicial to the administration of justice, as well as a violation of Rule 218, which requires written notice when you've been suspended. The panel recommended a 1-year suspension with a reinstatement hearing. The respondent filed exceptions to the panel hearing report, and my review of the exceptions in the brief, it does not appear that the respondent has disputed the findings that he violated 1.4, 1.16, 5.5, or 8.4D, or 218. He does take exceptions to some findings that support the violations of 8.1 and 8.4C. However, on page 17 of his brief, he argues that these false statements should not be considered as aggravating factors. So we'll wait to see if the exceptions are actually to the rule violations or to the aggravating factors. I'd like to just give a brief factual background of the case to put some things into context. As this court is aware, attorney registration is due July 1st. There's a grace period under the rule until July 31st to get that in. After that time, you're assessed a $100 late fee. The respondent mailed in his registration on July 29th, 2015. His registration was not received by the clerk's office until August 3rd of 2015. On August 8th of 2015, the respondent received the notice from the clerk's office notifying that his registration had been received late. This notice also notified the respondent that if a $100 late fee payment was not received within 30 days, his license would be suspended. It's uncontroverted that the respondent did not send in that $100 late fee within the 30 days. Consequently, on October 6, 2015, this court ordered an order of suspension. It was filed on that day. It was mailed out on the 8th of October via certified mail. On October 13th, we have evidence that the notice of the certified mail was left at the resident's house, which is the address he has on attorney registration. This is important, I think, in the factual dispute that's at issue here. On the morning of October 14th, the respondent called attorney registration and spoke to Debbie Yule. Immediately after the conversation, she sent an email to her supervisor, and that's found at Exhibit 9 in Volume 3, page 53 of the record. In there, she reported that the respondent had called about the late fee. She asked him if he got notice of the late fee, and he responded that yes, he did, that he didn't feel like he owed it, so he didn't send it in, that he tried to call to talk to someone in the clerk's office and had not been able to get a hold of anyone. And then this is a quote. He says that he has not received his suspension notice yet. At the hearing, in the transcript, you can see that Ms. Yule said that she could not recall the specific conversation that she had with the respondent. She did talk about her usual practice, which was if an attorney called about a registration issue, she would look him up on her records, she would see that he was suspended, and she would notify him of the same. She
Is
said
it
that.
your position that that historical fact as to the content of that conversation has to be proved by clear and convincing evidence?
The fact that she notified him that he was suspended on the 14th,
Well, yeah, as part of that conversation.
I think that clear and convincing evidence has to support the finding that he had actual notice on the 14th to support findings of dishonest conduct as they were made.
Okay.
She also stated in her testimony that she was very confident that she would have told the respondent it was her normal practice to advise an attorney who was suspended that they were suspended, and she was very confident that she would have done that. The next thing that I think is important to the factual disputed issue in here is that in the respondent's October 23rd, 2015 self-report letter, he states, he reports the conversation that he had with Ms. Newell, and then he states after reporting the conversation that even though I hadn't sent the late fee within 30 days of that notice, ultimately on that same date, I wrote the check and sent it in. Okay, and then later in his testimony at the hearing, he said that he actually sent that check in several days before October 14th. In his brief, he says, well, it could have been the morning of October 14th. And this is important for this factor. We believe that there was sufficient evidence for the hearing panel to determine, based upon clear and convincing evidence, that the purpose of that October 14th, 2015 call was made in response to getting the notice on October 13th. His testimony is, I wasn't calling because of that. I was calling to tell her that I'd sent in the late fee, but I wanted the registration to see if there was any opportunity for them to not negotiate the registration fee. I'd already sent it in, but I was hoping they wouldn't negotiate it. I think it's important to note that Ms. Ull's email doesn't say a word about him saying, I've sent in the check, will you guys not negotiate it at that time? I'm going to sort of fast forward now on the facts. It's pretty much undisputed from October 14th through October 17th that the respondent engaged in the unauthorized practice of law. He prepared pleadings, he went to court, he met with clients. It's also undisputed that he did not inform the court, his clients, or opposing counsel that he had been suspended. On the morning of October 17th, the respondent actually received the certified mail, he signed for it, and saw that he was suspended. It's important to note that it was that morning because subsequent to signing it and knowing of the suspension, he did several things. He mailed out a memo and a memo and a motion in an eviction case that he said he'd prepared prior to that date. He mailed some discovery responses. Again, I think the record is pretty clear of what happened on October 19th through 23rd. These are all things that happened after the respondent had actual notice, according to his testimony, of signing the certified mail receipt on October 17th. I want to get now to unless there's some questions on that, get to the issues that were raised in the brief. The first dispute was really, and this is the nature I think that goes to the dishonest conduct, or one of the dishonest conduct findings, was the actual knowledge on October 14, 2015. And Judge Atchison, to answer your question, I think that these are the factors that support clear and convincing evidence that show, according to the hearing panel, that the respondent had actual notice.
Does it even matter? I mean, he clearly practiced law after he claims he had notice.
I don't think it matters towards the unauthorized practice of law. That's correct. I think what it does matter to is the dishonest and deceptive practices. If he is misrepresenting, knowingly misrepresenting to the disciplinary administrator's office and to the panel hearing, I did not have knowledge, I knew nothing about it until the 17th, that's not true, and that formed the basis of those findings. But I agree, it does not matter for the unauthorized practice. And it doesn't matter for dishonest conduct that occurred post October 17th as well. I'm going to skip over that. I think the brief really lays out the evidence that supports the actual knowledge. He was on notice since August that if he didn't pay the late fee, he's going to be suspended. He called the clerk's office the day after the certified mail receipt was delivered at his house. Ms. Ull's email is pretty convicting or compelling, and then Ms. Ull's testimony at the hearing was also compelling. I think it's important to note when determining the facts, this court does not reweigh or assess credibility. Here the panel heard the respondent's testimony, they looked at the other evidence, and they found that there was clear and convincing evidence to support the finding that he had actual knowledge on October 14th, 2015. The next thing that I would just like to talk about is his argument. And I think it's the fifth sort of exception that he takes to findings of fact, and that's about the false evidence. He makes a dispute about this statement that he made in his October 23rd letter about weeks later, that he says that that's not material, that he got his notice that his his registration had been submitted weeks later, when in reality it was only 10 days. Again, the panel considered this for finding that he was trying to minimize his misconduct. Throughout this process, as you can see in the transcript, the respondent has really wanted to sort of lay some of the blame on attorney registration by saying, they should have gotten it by the 31st. I shouldn't have had to pay the late fee. I believe this is just another attempt to do the same. The other thing he wants to talk about is lapse in memories. He argues that some of these facts that were considered as false were not really knowing or intentional. They were just a lapse in his memory. He doesn't dispute that the statements in and of themselves were false. He just argues that there was no intent. Again, I would argue that the hearing panel was in the best place to judge his intent after listening to his testimony, after seeing all the evidence, and the clear and convincing evidence supported the knowing representation. He doesn't dispute several of the false factual findings that were made. I gotta real quick say that as far as discipline, we recommended 6 months discipline at the hearing. The hearing panel recommended 1 year with a reinstatement hearing. Because we recommended 6 months, a minimum of 6 months at the hearing, we're standing upon that recommendation today.
Counsel, I know you're out of time, but I'm going to keep you up here for a little bit. I have some questions about the Rule 8.1 violation.
Okay.
I want to be very sure that I understand what specifically the list of false representations are that support that finding of that particular rule violation.
Okay.
And I have down the alleged false statement about whether Ms. Ewell told him he was suspended on the October 14th phone call.
Correct.
The allegedly false statement that respondent made in his letter of December 3rd as to whether or not he informed Judge Gibbons of the suspension. That was a December 3rd letter to the disciplinary administrator's office.
Correct. I think that was in 2 letters, actually.
Okay. And then I have third, the representations made to the panel and the disciplinary administrator's office about the timing of when he sent his check in.
Yes.
Are there any others other than those 3?
I believe there is another one. I have listed his failure to disclose. I think it's in the October 23rd, 2017 letter. Failure to disclose the extent of his unauthorized practice from October 17th through the 23rd.
That's the self-report letter?
Correct.
So failure to fully self-report would be...
Right. Well, not only that, I'm sorry. I think if you look at his letter, there's a statement made. I have not appeared in any further hearings since being notified of the administrative suspension.
Okay. So two kinds of follow-up questions. One's procedural.
Okay.
Can Rule 8.1 violations ever be folded into the underlying disciplinary process, or should they be prosecuted in a new proceeding?
Well, I think in this particular case, and I want to check the record when I'm sitting down there, I believe that was pled in the original complaint to him.
Okay, so he was put on notice. In other words, when your office filed the complaint, you included this allegation.
I want to confirm that, but that is my understanding, because basically we had the evidence, because most of this was the false statements contained in the self-report letters.
Okay, but at least, as far as I read the record, at least the
Yes.
Alleged misrepresentation about the October 14th phone call
Correct.
was sort of sua sponte by the panel.
About
Am
the
I right?
timing of the check? Or
about
the
whether or not
purpose
he
of it?
received actual notice on October 14th. Was that also, did the disciplinary administrator's office allege that as a rule violation?
That it would form an 8.1 or an
Right,
8.4?
because I thought that was, correct me if I'm wrong, but I thought that particular alleged false statement arose at the actual hearing based on his testimony.
Right. I will look at the complaint. I believe that there, and I will check this too when I'm sitting down, but in the self-report letters, there was a statement to the effect of notice that he had no actual knowledge of the suspension until the 17th. So I believe that was pled in the complaint, that on the 14th, Debbie Ohl advised him.
So the concern I have, which is just can
Sure.
you really ding somebody for a false statement at the actual hearing within that same case? I mean, or would you have to bring a new case? You're saying that that fact pattern may not be present here.
I don't believe the fact pattern is present, but I guess just for the sake of, in case it wasn't, or is, excuse me, I would make the argument that an 8.1, first of all, and I'd have to do some case law search. I think it's happened before for things that have arisen during the course.
I think you're probably right. I looked at that.
And I think also that it's happened that if the facts pled in the complaint, which that's, I guess I'm going circular here. If these facts weren't pled in the complaint, I think an argument has arisen in the past that if they find a new rule violation based upon something that wasn't pled in the complaint but did not occur at the hearing, that they probably would not, that wouldn't be sufficient notice. But I guess I would just make the argument that, let's say it wasn't pled in the complaint, it just arose solely out of the hearing, that is due process satisfied. I would say if it's something, I don't even know if this has any legal support, but if a respondent has brought that upon himself in the middle of a disciplinary hearing, he was on notice. He was on notice that he had a duty to testify truthfully.
Okay. So that kind of segues into my second theoretical question, which is about these Rule 8.1 violations generally. Where can we draw the line? Is it possible to draw a line between conduct that's intended to be prohibited by this rule and simply defending yourself? Because every person who puts forward a defense and then the panel doesn't believe them, they find that your office has presented the more compelling case. Is that always, I mean, it seems like there's got to be a line somewhere where just defending yourself, even if you're disbelieved, shouldn't give rise to, not only did you violate the rules, but now you've got new violations because you defended yourself.
Mm-hmm. I think the line is drawn in the determination of whether there's clear and convincing evidence that you knowingly misrepresented the truth.
But isn't that, won't that always be sort of necessarily the case if there's a factual dispute, and if the respondent ends up on the short end of that stick, loses the factual dispute?
Well, I think that happens, and I see what you're saying. I mean, that's basically that you're saying a respondent is put in the place of not being able to come in and argue what their version of what happened is. But I think our disciplinary process, I mean, some people would argue about whether there's absolute truth or subjective truth and what the standard of that is. And I think that attorneys are put on notice through our rules that they have a duty to tell the truth. And
so losing is a double whammy. That's
well, I don't know.
No, it's not. I mean, we talked about that in Hodge most recently, which was just decided at the end of the year. And we made very clear distinctions between trying to defend yourself and defending yourself in a way that shows you are oblivious to the seriousness of the offense that's in front of you, like telling the truth versus not telling the truth, or dismissive of the seriousness of the allegations, and saying that those kinds of things are what gets involved with that offense, and that it's never used just to defend yourself. So I think those are qualitative things that we've used to distinguish that.
And using that, and I think that's right, but using that standard, can I focus on this October 14th phone call?
Absolutely.
Your position is, and the panel found, that the respondent's testimony and statements about the October 14th phone call violated Rule 8.1. But even if clear and convincing evidence supports the panel's finding that Ms. Uhl actually did tell him that he was suspended on the 14th, she didn't. And that's all inferential, right? There was no direct testimony to that effect.
No, she could not
She
recall
couldn't
a
recall.
specific conversation. That is
So
correct.
that's an instance in which, arguably at least, you've got contradictory evidence. I mean, this is a phone conversation. It can be remembered differently. Is that really a proper basis for a Rule 8.1 violation?
I believe so. I mean, I believe the panel found that the respondent's testimony was not believable. They found him not credible on that. And they found that he therefore made a knowing.
So anytime there's a finding of not credible, you're potentially at least on the hook for 8.1. That's the outcome here.
If it's about a material issue supporting that rule violation, then I would argue if they found that what he said was not credible and therefore not true, yes.
Okay.
Any other questions?
Thank you, Counsel. Mr. Holmes?
Thank you. Curtis Holmes appearing on behalf of the respondent myself. May it please the court, I would like to argue the facts in this matter because unfortunately they have been so conflated as to bear little reality or little image to the actual reality. Admittedly, I was out to save $100. This matter started when I sent out, admittedly, towards the end of the grace period, a fee and a statement to have my license renewed. Problem was, I had an individual in the same office that said theirs the same day, and theirs was received in time. I couldn't understand what had happened with the delay. And this wasn't the first call to the administrative office didn't occur on the 14th of October. There was a period of time over which I was attempting to contact them and say, is there a way that I can get out of paying the $100 fee? And I was not given a satisfactory answer. In fact, I was told on one occasion, we'll leave a message and we'll call you back. And so the call on the 14th was not an initial call. It was largely coincidental that it had taken place at about the same time that this the order was received. Ms. Ewell did not tell me that I had been suspended.
You knew at that point that you were on thin ice for getting a suspension order, didn't you?
Absolutely. And let me tell you, I was at that time struggling so hard and paying so much attention to try and prevent that from happening that I wasn't entirely cognizant of the fact that it could have already happened. And that's the fault.
You would agree that you concede the panel did not believe the statement you just made.
The panel didn't believe a lot of things. In fact, to be honest with you,
specifically, they didn't believe.
They didn't believe anything I said.
Counsel, specifically, they didn't believe that your representation that Ms. Ewell did not tell you you were suspended on October the 14th. Because they found that she did tell you that.
Among other things, yes. The fact is that she did have an email. She presented that email. Nowhere in that email does it say that she told me. In fact, the email is entirely, as I understand, consistent with the conversation that I gave, or with the testimony that I gave. The only thing in there that's related to that particular issue is that she asked me whether I had received it, and I said no. And at that time, I truly did not know. That being said, I believe that I had a duty to inquire, at the very least, because I knew I was on thin ice. That was why I was trying so hard to get it taken care of. I did send the check out when I could, when I did, with an attempt to try and get this matter resolved. With respect to the...
Sir,
Yes.
when did you get notice that you had received a letter from the clerk's office? They sent a certified mail of the order of suspension.
I mean, when did I receive the notice that I'd received something from the Supreme Court?
Yes.
I think it was mailed on the 13th, although as I testified, I didn't pick up the mail, so I don't know exactly when I saw it. And frankly, I don't recall.
Okay.
I did see it before Saturday when I picked it up.
You had some kind of a notice that you had received something from the Supreme Court before Saturday.
Yes, but I did not know what it was.
Okay. Did you have any cases pending in front of the Supreme Court where you were counsel or the Court of Appeals at that time?
To be honest with you, I don't recall.
Okay.
The one thing I can tell you is, though, it would have made no sense if I had actually known, but actually been told, then I would have known that the little orange card that I received was in fact the order of suspension. It would have made no sense if I was trying to deceive someone, or deceive this body.
Well, I guess I'm trying to figure out, could it have been anything else? I mean, what did you think it was?
I didn't know. I've actually received other things from the Supreme Court that have not been such things. I didn't know. But it would have made no sense for me to file the documents that I filed on the 19th, which were prepared before the 17th, and pick up the certified mail on the 17th. It would have made entirely more sense for me to have gotten that stuff filed before ever picking that up, if I would have known that's what it was. As far as the mailing of the check is concerned, at the time that I sent the letter, it appears that I recalled that I sent it out that morning. It would have been before the phone call. A year and a half later, I didn't remember. And so my testimony was not based upon recollection. It was based upon a monthly checking account statement that showed when the checks would have cleared. And so I had estimated that, okay, it probably took place, it would have had to have taken place between about the 10th and the 13th. I didn't think that, well, yeah, it could have been the morning of the 14th. But I knew that it was before I made the phone call. I made that phone call the morning of the 14th.
Sir, I wanted to ask you about, you got the notice on Saturday the 17th.
Yes.
And you were suspended from the practice of law at that
Yes.
point, correct?
Yes.
You had actual notice.
I had actual notice at that point, absolutely.
All right. It's not just a suspension from appearing in court. It's a suspension from the practice of law, correct?
Yes.
Okay. In your self-report letter on the 23rd, you only talk about matters in which you appeared in court.
Right.
Isn't that either obtusely or deliberately under-inclusive of what you were suspended from doing?
I agree that I should have provided more information. I agree that I neglected to do it. I would advise that I ultimately did provide that information. The only thing I could indicate is on that particular morning, I was in the process of preparing to drive out of state to attend my daughter's 30th birthday. And so I was, to be honest with you, rather rushed. I did not take the time that I really should have to complete that. And I was largely focused on the most horrible thing.
You're defining a universe here of what you're reporting is your court appearances, not your practice of law.
Right, and that's what I was going to say. To me, at that particular time, that was the sin. That was, as I saw it, the worst thing I could have done is appeared in court knowing that the license had been suspended. And so that's where I focused my attention. And I should have informed the court of the other matters. If I may, I'd like to speak a little bit to a couple of things. One is I have some very serious concerns about the hearing panel. They had found findings of dishonesty that I'd indicated were largely just based on not a fully accurate memory. Specific to the conversation that I had with Judge Gibbons, I reported that several weeks later. I had specifically advised opposing counsel prior to the hearing taking place that I had received the suspension. It was fully my intention of going in and reporting the same thing to the court, and that's what I had recalled, that I had actually said that. Turns out upon the history, or upon looking at the record, the court actually informed me of that fact. But that wasn't a misrepresentation. It was just a lapse in memory because I had said the same thing to opposing counsel. But the fact is, if you look at the findings of the hearing panel, there are things in there that were never, not only are false, but were never alleged. and there was no evidence presented. They found that I made a statement to Judge Gibbons in the letter on October 23rd. They had the letter. The fact is, that letter was written before I ever had the conversation. Secondly, they found that I appeared at a hearing on October 15th and requested a continuance. I never appeared at any such hearing. I had talked to opposing counsel several days earlier to tell him that I can't appear. I would not be able to appear at that hearing, and to ask if he would request a continuance on my behalf. And he did so.
Which hearing is that?
That was a hearing on the...
Is that in Johnson
in
County?
Leavenworth County.
Oh, Leavenworth County.
Leavenworth County. Beyond that, they also found that I made no effort to notify anybody of the license suspension and to essentially notify opposing counsel and my client and the court of that. That was contrary to my testimony and contrary to the truth. I had cases in Johnson County. I had no difficulty in Johnson County, and in fact notified court counsel and the court opposing counsel and my client. I had a particular notable meeting with Judge Kevin O'Grady on that occasion, in which I explained to him what had happened. I had already informed my client and opposing counsel of the situation.
Counsel, I'm going to interrupt you because
Sure.
I want to get these facts as close. I mean, I want to understand the facts and what you're arguing as well as I can. I understood you to say about 60 seconds ago that you did not appear in a Johnson County District Court case.
I did not appear in a Leavenworth District Court case on the 15th.
Okay. So, and what the panel found is that you, correct me if I'm wrong, that you appeared in a Johnson County case and got a continuance.
I think that
sounds like we might be confusing.
I may have been
Leavenworth.
confusing it because the only thing on the 15th was a hearing in Leavenworth where there was a continuance requested, but I had talked to opposing counsel several days earlier about that.
You're not contesting that you appeared in Johnson County and got a continuance in that case?
Not a continuance, no. I think that was a misunderstanding. That's what I understood, because the only evidence in that regard was in reference to the Leavenworth County case, so I think that they just misunderstood the county. But let me talk to you a little bit about the case in which I did appear. And I think that the court needs to be aware of the seriousness and the problem with this particular matter. This is the GM case, this is the eviction case, and this is where I filed paperwork on the 19th. This was a particularly nasty case. This was one in which my client, at least the wife, apparently had an affair with the landlord, which had ended rather disastrously. And he was essentially, in a very nasty manner, trying to force these people out of the home that he had leased to them. He had started in early September by making accusations of violations of the lease, which we had a hearing on, and which pretty much established weren't true. And then later he submitted a 3-day notice claiming they paid absolutely no rent and requested that they pay rent within a period of 3 days. In fact, that was false. They had paid rent. And the rent for that first half of the following month was tendered within a 3-day period. And this is what the result of the hearing on the 14th, which I unfortunately stepped out of the court chambers briefly because my clients were running late, and the opposing counsel was able to get an order by default. I acted to try to prevent what I saw was a manifest injustice, with people being kicked out of their home based upon a lie. Now, I regret that. I regret that tremendously. But I do not regret that because of my intentions. I believe my intentions were to correct an injustice. Why I regret that is because rather than attempting to cure an injustice, I didn't really realize at the time, but I realize now, in effect, I had become Don Quixote. That because of the suspension, it had no effect. And that's something that I realize now and something that I regret, that I didn't have power or the potency to be able to prevent an injustice that I clearly saw. But
Not only that, you denied your clients the opportunity to get somebody who was licensed to protect their interests.
They wouldn't have had the time.
Well, that's not your call, is it?
No, but that's how. Admittedly,
That's how maybe
I
it
saw
appeared to you.
That's how it appeared, and I grant it. The fact is, had I known earlier at the hearing on the 14th, I think I would have been able to do the same thing with Judge Gibbons that I was able to do with Judge O'Grady a few days later.
You
in
did
Johnson County.
that, but you did that on the 19th, right? Filed those papers.
I did file them on the 19th.
How
but it
come
was
that
to-
didn't make it into your self-report letter of October 23rd?
That's what I'd indicated, is that I was essentially rushed on October 23rd. I should have, absolutely. I should have done that. But I was focused more on getting out of the state.
What do you think we should do to you in this case? I mean, you've admitted various violations. They aren't all the ones that the panel found. What do you think we ought to do to you?
You know, I had requested a period of suspension that I think should be suspended and placed on probation. The disciplinary office rejected that, which has been concerning to me, but I do want you to be aware of what I've done. I have been meeting with Mr. Fowles, who works in my office. I have attended, in fact, I've joined a men's group with my church, and I'm teaching that on 2 occasions per week. I work out physically on a regular basis. I have kept on top, at least as well as I can. Sometimes you get a little bit behind, but I've kept on top of the cases that I have. I have had no further issues. I am trying to do the best that I can under the circumstances.
Have you submitted a probation plan?
I have submitted a probation plan. I'm following most of that. I can say that something else that happened that I was not aware of at the time of this is that I do have a physical problem that I became aware of that does impair my focus, and I believe possibly my judgment. I'm having that treated. It's something that I learned last summer when I had a few occasions and nearly passed out. And so there is a physical problem that I had for a number of years that did impair me, at least to some degree, and I'm addressing that as well.
But do I recall correctly, you had not implemented your probation plan before the hearing panel?
Not fully. To some extent, yes, but not fully.
And your supervisor was not aware of the terms?
Yes, he was. Well, in part. I don't think he'd seen everything. We had discussed it. I think he testified to that. Additionally, I also talked about teaching a CLE course. I have done that. I did that last summer. I would like to be able to teach a CLA course specific to ethics. I think that addressing this particular issue would be highly beneficial.
So I'm not sure I understand your answer to Judge Atchison's question. You are requesting that we put you on probation?
I'm asking that I be allowed to be put on probation. Yes.
And that plan would be the same plan as what you had submitted to the
No,
panel?
I think that there needs to be some modifications because I think that I based that plan largely on others that I had seen. And when it was so, I guess, soundly rejected by both the disciplinary council as well as the hearing panel, I went back and looked at things and I thought, what would actually work? What would actually truly address this? And those are the things that I've been endeavoring to do. So, again,
Counselor, just really quickly, am I correct that the only rule violation that you're contesting is Rule 8.1? Or are you also contesting 8.4C and or any others?
No, not those others, but for different reasons. I again deny the knowing unauthorized practice of law prior to the 17th.
But you're not denying that you violated the rule
No,
prohibiting the
and I think it was
unauthorized
specific, most primarily specific to the GN case, which I again have asserted. I believe that there is a mitigating factor in that.
Again, yeah,
I was
a
trying
lot
to
of your
create
argument
manifest
goes to
injustice.
mitigating factors. I'm just trying to peg down.
Right.
There are a lot of found rule violations, and the
No,
only rule violation
Further
that
back.
you are here saying, "Whoa, I didn't violate this rule," is 8.1. Is that right?
Except for, I think, the October 23rd letter. I would admit that I did not fully disclose.
Okay,
the-
so you would concede that
I would
at least
concede on
at
that
some
level.
level you violated all
Absolutely.
of the rules that the disciplinary.
Yes.
Okay, thank you.
But not to the extent that alleged.
Other questions? Thank you, counsel.
Thank you.
First, Justice Deagle, I did check the complaint, the facts all supporting the 8.1 violation, including what was that WL put him on notice, told him on October 14th that his license was suspended, and also referring to his self-report letters. Rule 8.1 was pled in the complaint as
Okay.
well.
I appreciate you checking. that.
Sure.
Thank you.
I want to go to clear up something real quick. I'm not sure, but I thought the respondent was arguing before you that he did not appear in court on October 15th, 2015 in Johnson County. I would just direct the court to the record on volume, I believe it's 3, pages 87. It's Exhibit 17. It's the pleading. It's a court order in the Johnson County case. It's on the 15th. It's a continuance of a temporary order of protection notice, hearing, and summons. If you look at the docket sheet, which is on page 88, the docket entry on October 15th, 2015 says plaintiff appears with Holmes, defendant appears with Garrison, continued until November 5th of 2015. So there is evidence to support that he did appear on October 15th in Johnson County hearing. We're not talking about Leavenworth. He did appear on the 15th in Johnson County. Mr. Holmes takes issue with something that was really just in a parenthetical in the hearing panel report, where he said he didn't notify any clients. The first time he notified, and I'm paraphrasing, the first time he notified anyone was on October 23rd. I want to make it clear that their finding of a violation of Rule 218 is not that, he didn't notify everyone, or that he didn't notify anyone. I mean, the reality is that 218 required him to notify everyone. And if you look at his response, his testimony is that he just notified people in Johnson County that he had hearings that week. So he didn't even notify all his Johnson County clients either. He argues he wanted to, basically as a mitigating circumstance, to say that in the eviction case, that he was really doing what he thought was to prevent manifest injustice. I think the brief points out really well that you can't create an emergency situation and then argue that as a mitigating factor. I would go beyond that and say that really starting in August, when he got that notice that he was going to be suspended if he didn't pay the late fee, he was on notice at that point in time. So the fact that all of a sudden in October, whether the 14th or the 17th, he learns that he has been suspended, he created that problem for the clients on his own behalf. Probation. He requests today to be put on probation. It was argued at the hearing that he had not complied with 211G. He had not put in the provisions of his probation plan. His probation supervisor testified at the hearing that they had discussed it, but he had never read the probation plan. That's what the testimony was. We would argue that probation is not appropriate in this case. We're dealing with some serious allegations of dishonesty. This court has found that probation is really not suitable in dishonesty cases. Not only that, I'm not aware of an affidavit that has been filed with this court saying that the probation plans, that he's been complying with them. I did not check today, but I'm not aware of that affidavit. So again, we would continue to argue that probation is just not the right sanction in this case. I'd also just like to close with this. We stand upon the recommendation of the 6-month suspension. The respondent in his brief cited to a case in Ray Sutton where he said, that was much more significant than what happened in my case. And in the brief, we point out, first of all, that this court treats each case on its own unique facts. Then we pointed out the facts in Sutton that Mr. Sutton had no prior disciplinary history. The respondent here has some prior disciplinary history. He has some prior disciplinary history of a suspension, and in that suspension, there is a finding of dishonest conduct within that. So I think that's a compelling reason why a minimum of 6-month suspension. But I also like to point out what the court said at the end of Sutton, where they did place him on suspension for 6 months, but Mr. Sutton testified, I'm old, I'm never going to come back to practice. Plus, he had like 10 years of CLE requirements to meet. So the reality is he probably wasn't going to come back to practice. But the court said here, respondent is cautioned, however, that any future unauthorized practice of law, no matter how well-meaning, will likely result in disbarment. And I just point that out to show that, you know, unauthorized practice, when you know that you're suspended, is not something to be taken lightly. So for that reason, we stand on a recommendation of a 6-month suspension. Any questions? Thank you.
Thank you. Thank you to both counsel. We will take this matter under advisement, and the court